Thank you, Diane. Thank you for inviting me to be here. Can you hear me okay in the front and in the back? Is this picking up all right? Great, thank you. So I want to tell you a little story. I was at a party a few nights ago, and there was a physician, an engineer, and a lawyer that were talking about their various professions, and they were all getting a little high-strung about how valuable and important and prestigious their profession was. And finally, the physician said, well, you know, the medical profession is really the oldest profession, therefore the most honored profession in the world, because you recall that God took a rib out of Adam and created Eve. Now that's a pretty fantastic surgical procedure. So obviously the medical profession is the oldest, most honored profession in the world. And the engineer thought for a moment. He said, wait a second, you know, out of chaos, God created the heavens and the earth. Now, talk about engineering feats. That's pretty amazing. So obviously then the engineering profession is the most honored and oldest profession in the world. The lawyer said, well, who do you think created all that chaos? So I'm going to talk a little bit about chaos today. And just in terms of a background in this field, when I was in the Air Force JAG around 1970, having fun in Colorado Springs with my family and young child, I had a chance to go to a mini med course at Andrews Air Force Base outside of Washington, D.C. for 14 weeks and was assigned to the School of Healthcare Sciences at Shepherd to be an instructor. Anybody been through that program at Shepherd? So you all are all just way too young, because back in those days, all the physicians, you know, had to serve in some way because the Vietnam War was going on. And so a year later, I got a chance to go and be an attorney for a medical center at Keesler, and covered Keesler and 17 hospitals. It was the House Counsel duties, and also worked with the U.S. attorneys and claims that could be filed by dependents and retired persons. The Air Force, around 1968, set up a program, invited a bunch of majors in, and assigned them to 6 regions of the United States after some training to do work at those hospitals that focused on dealing with professional liability issues. And I was in the second round of that, replaced one of those majors as a young captain. Very interesting and really interesting job dealing with professional liability issues back then in 1971. So there already was a crisis in the military and a crisis generally across the United States even back then, as professional liability premiums seemed to increase, numbers of cases expanded, et cetera. So I had a chance to go to the AMA in 1973 in Chicago, and one of the projects that I was involved in there was to develop some tort reforms, some language for states to use. California was leading the nation in professional liability at the time. Some of you may remember that, and had already worked on some legislation and had passed some in 1973. And we were asked to look at that law, other legislation, develop some legislation, and we developed about 20 different little tort reform bills that we distributed to the state medical societies and said, here's some things that we think you ought to consider in addressing this crisis. I remember going into Bernie Hirsch's office, who's a brilliant lawyer. He and Betty Jane Anderson, whom I worked for at the AMA, privileged to work for 6 years, brilliant people. And I went in and I said, I don't think some of these tort reforms are going to be constitutional, because you've got open courts provisions in the state laws, you've got due process protections under the federal law. Bernie Hirsch said, you know, some of them are going to be thrown out, some of them will be affirmed, but we still have to write them up, and nobody knows for sure what's going to work, but we're going to try to put out the best product that we can. So going back then to California in 1973, California passed some significant tort reforms. One of them was a cap on non-economic damages. There were many other reforms that were passed. We'll talk about some of those later, but if we focus on that one, that seems to be the key in all these state legislations, is you get a cap on non-economic damages. So that's pain and suffering, loss of consortium. It's not lost wages, it's not medical expenses that you can prove, pain and suffering issues. That seems to be the key. In 1975, a lot of other states passed some statutes. Texas did. Texas put forth a Keaton Commission in after the 75 legislative session. Dean Page Keaton was the dean of the University of Texas Law School. He was a tort law expert, and his commission came up with a series of recommendations, some of them similar to California, some other ones that weren't exactly the same as California. Those were passed by Texas in 1977. I had a chance to come back to Texas in 1979 to be general counsel for the Texas Medical Association. My wife had been in Chicago long enough and decided we needed to go back south, so we came back to Texas. And what I was seeing in Texas in the early 80s was a very plaintiff-oriented Supreme Court. So every time the case got up to the Texas Supreme Court, it seemed like a new tort remedy was created or a tort law that had been passed was overturned. And so in the early 80s, we started working on that, trying to figure out how are we going to deal with this problem. And I remember going and talking to Kim Ross, who was our legislative director at the time. Some of you may remember him or know of him. Saying it doesn't matter what we pass in the legislature, the Supreme Court's going to throw it out. The Supreme Court's making the tort law, which was true in some other states as well. Just using Texas as the example because I'm most familiar with that one. And we got to focus on the Supreme Court. In the mid-1980s, the California Supreme Court upheld their cap on non-economic damages. Very narrow vote. My recollection is it was a one-vote difference in the Supreme Court on whether that would be constitutional or not. In Texas, the cap on non-economic damages was thrown out at about the same time. And so we started working on the court races. And about 1984, we started I call it a coffee clutch meeting at one of the local Austin clubs where the lobbyists gather. We'd meet monthly and talk about tort issues and why we needed to focus on the Texas Supreme Court and the Texas Courts of Appeals and the lower courts. And we invited business, we invited hospital folks, medical folks, associations, insurance companies, and started talking about these issues. And by 1986, we had a pretty good coalition working on the codes. We developed some slate cards here, the candidates that we thought the people should support, and in 1986-87, the court changed. And we finally got a more conservative court, which we felt would uphold most of these tort reforms that we were interested in. Unfortunately, many of the reforms had already been overturned by the Supreme Court, and so of Texas. So you wouldn't see the new court come in and make those changes that quickly. Stare decisis would require them to adhere to the previous law. So we had to go back and then try to change or add to the laws in Texas again. So there were some constitutional amendments that were needed back then to address the constitutional issue, but it really wasn't feasible for us to get that done to try to restore these caps on non-economic damages. So we tried legislative efforts in the 1990s, and we passed some things, but not much really helped. And in the late 1990s, we had a lot of issues with expanded tort activity. So in early 2001, we said we need to put another coalition together to really work on this issue. That coalition is called the Texas Alliance for Patient Access. And so the Texas Medical Association, Hospital Association, our Liability Trust, even Blue Cross Blue Shield, others got together and put together really about 200 plus organizations to work on and address the tort reform issues in the early 2000s. There was a lot of bleeding going on at that time because premiums were going up, increasing. Doctors were having trouble getting any relief. Their premiums were going up. There were doctors that couldn't buy insurance. There were areas of Texas where The insurance companies wouldn't write insurance because of the attitude of the courts and what they thought the jury, sort of a golden triangle from Beaumont down to the valley, that it was very difficult to find insurers that were willing to insure, and certain specialties were having great difficulty getting insurance. So we were able to gather that data and put that together and develop a rational basis for the legislature to act using those resources and that data. This is a chart that shows the losses that were occurring in the late 1990s. So if your losses are in excess of your premiums, what happens? Your insurance companies are either going to go bust, or they're going to leave the state, or they're going to change their underwriting criteria. They're going to do something to stop the bleeding, and that's what we were seeing in the late 1990s. Really big issues with carriers. And we had somewhere around 17 carriers writing insurance at the time, go down to just 4 carriers, and they were all limiting their coverage options at that time. There were lawsuits filed. Physicians were still winning a lot of those lawsuits, but it's expensive to try to defend those suits. We saw a big growth in non-economic damage awards during this period of time. In 1991, the data showed that 35% of the total verdict cases that went to verdict were non-economic, but 65% went to verdict. So we were seeing verdicts in excess of the actual policies that physicians were able to purchase, which is a real issue. So what happens when you have a claim that is beyond your policy limits is physicians are going to be put under the pressure of writing a letter to their insurance company saying, I want you to settle within policy limits. And the insurance company has a good faith duty to represent you and deal with the claim within those policy limits. So there's a big pressure to settle. And if you have a claim for $10 million in non-economic damages and you have $1 million worth of coverage, it can be disconcerting. So this just shows you that we had 17 carriers at one point, and a lot of them left the state. Some of them were risk retention groups, risk purchasing groups. Some were admitted carriers, and all but 3 or 4 were really left writing policies in Texas, and they all backed off in terms of what they were able to pay. Raising premiums. I had physicians, I was getting physician calls on the phone, literally crying because they could not buy liability insurance. And of course, one of the problems with that is that some of the hospitals required liability insurance in order to practice there. A typical managed care company required liability insurance in order to stay in the network. So they were in a real pickle, a real fix trying to deal with this. We had 6,500 doctors in Texas who were non-renewed by their carriers during this time. And that was a problem. So they would go to what we call the Joint Underwriting Association. And that is a sort of a backstop entity that was created back in 1977 in our tort reforms to address the problem of physicians who couldn't buy insurance in the private market. Covered physicians, hospitals, and other health care carriers. At one time, we had 3,000 physicians in the JUA. So the JUA charged premiums in excess of what the market rate was, and the physician was liable and agreed that if the JUA needed the money, it could go back and assess the doctor again the same amount of the original premium. So if you paid $10,000 in premium for a year and the JUA didn't have money to cover its costs, they could come back and ask you for another $10,000. And in fact, that did happen 1 or 2 years during this period of time, which really got everybody excited, as you can imagine. So what are we going to do about all these issues? I remember getting a call from a physician in the Valley whom I knew, one of our leaders, and he was very frustrated. So he was down in the Valley in Texas, is down near the border. That was a very hotbed of lawsuits, concern about the fairness of the courts there, the pool of jurors there in that area, and they were totally frustrated, having trouble getting liability insurance, and they wanted to, protest, close their offices. And I said, well, who's going to be harmed by closing your office? Well, we don't really want to do that because the patients are going to be harmed, and the insurance companies that have to pay for those patients' care, they might be happy because they won't be getting bills from us. How do we do this? I said, well, I don't know if that's a good idea to do that, but what you could do is petition your government. So there are constitutional protections to petitioning your government. It's not a boycott. You're petitioning your government. You might have to close your office down for a morning or an afternoon in order to march to the courthouse or march to the Capitol to express your concerns. And they started talking about that. They said, that sounds like a good idea. We're going to march to the courthouse in McAllen, Texas, and raise these concerns and petition our government. And that kind of caught on. So it happened in San Antonio, Corpus, El Paso, other spots across Texas. And it kind of led the public awareness of the problem and the issue and helped us set the stage for some reforms. Now, in 2003, we were able to package 100 tort reforms in one place. I'm going to talk about the cap on non-economic damages as the key to that. There was a cap in 1977 that was passed, was a $250,000 cap on non-economic damages. And we felt like if we could get that cap again, that would help a great deal. We had talked to some actuaries, hired some actuaries to tell us, okay, if we get this cap, what will that do to premiums? And the actuary said, if you get a cap at 500,000 or $1 million, that's not going to help you much. But if you get it to 250,000, then we're willing to say that that's going to make a difference in the expense and the premium that's paid by physicians. So Lou Goodman, who's our executive director, and he was at that time, and I started working on this issue, and I can remember toward the end of the legislative session, in addition to all the other reforms that we had, this cap on non-economic damages was the key, being ping-pong between the lieutenant governor and the speaker of the House, back and forth on this issue of what the cap should be. And of course, the trial lawyers and the front organizations that they had organized were on the other side of that issue. What we're able to do is to come up with a stack cap. So the cap in Texas works like this. If you sue a physician or a group of physicians, a hospital or a group of hospitals, a nursing home or a group of nursing homes, there's a $250,000 cap on each type of provider or physician. So you can get $250,000 from the physicians, non-economic damages, $250,000 from the hospital, $250,000 from the nursing facility. So it's a stack cap. So the possibility is as high as $750,000, but maximum $250,000 for the physicians in the group. And there are no exceptions. There are about half the states actually about 36 states is what I read, have caps on non-economic damages of some type. But some of the states have exceptions, and exceptions tend to grow. So we were very concerned about not having exceptions to this cap. And there are no exceptions that actually were passed in the 2003 legislation. And it's not indexed for inflation. So there's a big pressure to say, well, we ought to index it for inflation. And if it had been indexed for inflation, it'd be up in the $450,000 category by now. So, but it does vary depending upon the type of defendant that is in the lawsuit, as I described to you. There were other elements of the cap as well. The cap on wrongful death, there's a total economic cap on wrongful death for economic damages and non-economic damages. And that was upheld by the Supreme Court back in as I recall, in the late 1980s. You might ask, well, why would you be able to cap wrongful death cases, total cap, and not be able to do that in other cases? Well, it doesn't necessarily make a lot of sense, but I'll tell you why there's a reason for it. So Texas and a lot of states adopted the English common law, which allows for due process, open courts provisions. And there was no remedy for wrongful death. It was not a part of common law. That was a statutorily created tort. And so the court said, since the statutes, the legislature created the tort, the legislature can create the remedy and limit the remedy. And that was the rationale for upholding a cap for non-economic damages. So there is a wrongful death cap in Texas for non-economic damages, and many other states have caps that have been upheld as being okay. There was also this concern about medical bills. We want to have, if there's an injury that's wrongfully committed, proven, we want to have the patient compensated for their medical bills or hospital bills. But, what is the right amount? So I might get a bill from my hospital for $50,000, but I know it has a contract with Blue Cross Blue Shield, and they're going to pay $20,000 on that bill. So do I get the $50,000 amount or the $20,000 amount? And so the legislation talks about, paid or incurred. What is the actual amount that's actually going to be paid, and that's the amount that you can include in your economic damages. And we also did a lot of work trying to shore up our expert witness requirements, so that if you're going to have a true expert testify, file an affidavit to support a notice of intent to sue, to actually testify in a deposition or in the court hearing, you want to have them actually be qualified and expert in the field that they're talking about. And so we beefed up that area as well. Another elements of our tort reforms related to emergency care. So we are having a real problem with professional liability suits in emergency scenarios coming to the hospital, either to the emergency room or to the OB suite. And the thought there was that the hospital personnel, the physicians, are really at a disadvantage in many of these emergencies because they've never seen the patient before, they don't have their records necessarily, and they're coming in, there ought to be a different standard, a higher level standard that has to be proven before there's liability. Otherwise, we're going to lose our ability to attract people in this area. And so we heightened the standard to a gross negligence standard from a negligence standard. You've got to prove gross negligent if you're going to have liability in the emergency setting coming into the emergency room. And that's been upheld also by our new Texas Supreme Court. There also is a possibility of periodic payments for future medical bills. So what we were seeing too often was a patient that was injured that got compensation would spend that money down in a couple of years and wouldn't have the ability to be able to invest and keep that money and not sort of waste it, and then be a ward of the state and not have any insurance coverage because they spent all the money or any award money. So this law allowed for periodic payments of future medical bills as a part of the award. Now, because our 2003 tort reforms provided for a cap similar to the one that was adopted in 1977 that was declared unconstitutional by our Texas Supreme Court, we felt in order to make sure that this law was going to be successfully defended, we needed a constitutional amendment. So that requires action by the House and Senate of the Texas legislature and a vote of the people approving the constitutional amendment. So we went on a battle after the tort reforms of 2003 to get the constitutional amendment put in place. And it was a PR campaign. The trial bar initially was arguing in the media about this problem with respect to physicians in hospitals and not being able to get full rewards from those entities, and that wasn't working for them. they didn't move the needle in all of their efforts. So they switched tactics, and they started talking about this constitutional amendment would protect the polluters and all the bad people in Texas. Not talking about physicians in hospitals, but talking about, the bad polluters and other folks. And even though that wasn't really true, didn't stop them, and that was making some headway in the media, according to our polls. So we were very concerned about the direction of what the votes were going to be because of the change in the strategy by the trial bar. Nevertheless, in September, the vote was taken, and we just barely etched out the win in September, upholding the constitutional amendment. We're glad that it was in September, and that the trial bar didn't discover its strategy, untruthful as it was, until later, because we might not have been able to defend that through a November election without that change. So we did get the constitutional amendment, and of course, immediately what happened is there was a federal lawsuit filed trying to overturn that, and that was not successful. TAPA and TMA and THA worked to make that lawsuit unsuccessful. This is a view of the law review article that was put out. It's really a book. It's almost 400 pages long. We put that out in about 2005, and it talks about each tort reform provision, what the old law was, what the new law is, what's designed to do, what the rationale was for. And the courts have used this a lot. So it's been used in briefs and cited by Supreme Court and the appellate courts in their decisions, which is, of course, what we designed and intended for it to do. We are in the process of updating this. So sometime this spring or early summer, there'll be an update of this particular document, which will include references to all those cases that have interpreted the 2003 tort reforms and what happened to them. And most of the reforms have stayed. There are a few that have been interpreted away, but 98% of them have been maintained. So this just talks about our educational program, what we've tried to do since 2003. So every legislative session, every court tort action involving physicians or hospitals, there's an effort to erode this statute, to change the law in Texas. And so it's a constant effort to fight the court battles. It's a constant effort to fight the legislative battles. And so far we've had pretty good success in Texas in getting that done and reforming the system. And the key is, who are the judges? Who's in the legislature? Who's the governor? All those things are very important. And to keep the message out there that without this kind of relief, access to care is going to be hindered, and there's going to be a real problem in getting the care that you need. Sometimes it's hard to keep a coalition like this together. So you've got insurance companies that have different ideas, whether they're a liability carrier or they're a health insurance carrier primarily, or whether they're a physician or a hospital. They're going to have different ideas on how the tort reform ought to be supported or changed. And the important thing is to trying to keep everything together. So one of the rules that we have at TAPA is consensus. We want to get consensus from all the players before we go forward. We don't want to try to divide and conquer with anybody. We're very active in judicial appointments and elections, still have those slate cards, and it's still a big fight to make sure we've got judges that will apply the law and won't be too creative. The other thing that happened in 2003, it was actually put ahead of our tort reform bill, was a bill which strengthened the Texas Medical Board's authority. And in fact, now Texas Medical Liability Trust, which is the major insurer in Texas, that was created by TMA back in 1978 as part of the tort reforms that were put in place, tells me that they have more cases, because they have a med defense policy, which covers investigations by the Texas Medical Board. They have more cases involving the Texas Medical Board than they do professional liability cases now, which is an interesting development. TMLT's med defense policy covers not just actions by the Texas Medical Board, but if you're being investigated by the Office of Inspector General for fraud or abuse, or Medicaid or Medicare, hospital staff privileges, there's a host of additional riders, add-ons to the traditional liability insurance policy that are offered by TMLT. We tried to figure out how to do that as an association back in the early 1990s. Because of underwriting and other costs, we said, can you do this, TMLT? Because they insure about half the doctors in Texas anyway. And so they have riders on their policy to cover these other activities that are related to medicine, but they're not technically professional liability. So they now have a coverage for employee lawsuits. There are probably as many employee lawsuits as there are, maybe more than professional liability cases. So they've covered some other things in their policy besides just professional liability. So as you're out there in the world, and whether you're insured by some offshore company that your hospital has, or some stateside company, you want to make sure you know what the breadth of your policy is, because not all policies are the same. You want to be concerned about cyber risk insurance, these other matters. TMLT has that coverage, and you want to think about where are the other areas that I'm exposed. Is an employee going to sue me? Do I have a cyber risk thing? Is there going to be HIPAA going to come up and bite me? What kind of coverage do I have for defense costs? And if I have to pay an amount, what are they going to be? So all those things are important in addition to the role of the licensing board and whether you're covered for those costs. If you're investigated by the licensing board in your state, those costs can run up really fast. And in the Texas system, if you go through a administrative law judge hearing, which we call a SOA hearing, you can spend $100,000 in defense costs. It's costly or more costly than a medical professional liability action. So you want to make sure you've got good broad coverage for your risks. When you try to do these reforms, there is huge pressure to water all these things down. And I mean, Lou and I were really beat up when we were trying to hold this cap of $250,000 by the lieutenant governor and the speaker and the physicians that were with us. You know, they'll do everything, lock you in a room, we'll let you go to the restroom, almost literally, to try to get you to do a deal, but you have to hold firm and get the best deal that you can and not take something that's half a loaf, because you may not get to come back and do it again. Of course, we talked about that. You got to keep your coalition together. You've got to be out there talking about these issues constantly. We encourage our physicians to know who their legislators are, to meet with them on a regular basis if they can support them, to contribute to their campaigns. It's a grassroots effort, and when we're testifying in the legislature, we like local physicians to come in that are in that legislator's district to come in and talk about the issues, and that's much better than lobbyists doing it, to have those physicians actively and involved in the issue. We have, once a month, we have First Tuesdays where we invite physicians to come in wearing their white coats and descend upon the Capitol. And the last Tuesday, we had 300 plus doctors, medical students, and residents come in to attack these issues in the legislature, and that all helps. We think that if the cap goes up, if these reforms are eliminated, the crisis will return. We'll see physicians less willing to provide care in risky areas. High-risk patients, lots of problems will happen again, and that's why we continue to do it. So just to show you some data of what's going on. Here's a chart that shows the bottom line, shows the trend in terms of what we would expect the physicians in Texas to increase over a period of time from 2002 to 2017. Without tort reform, we still expect an increase in physicians, but with tort reform, we believe we've got 11,000 plus more physicians in Texas than we used to have because of tort reform. And I know physicians have a choice of where they wish to practice. City, rural, north, south, east, and west, and part of that decision is what is the liability climate in that state. And I've seen that in the marketing information that's provided to physicians by folks that deal with physician employment or physician opportunities in certain areas. And I know it's important to physicians. What is the climate in that area? And as long as your state can maintain a good climate, you're going to have more folks interested in joining you in that state. This shows what was happening back when we were in the crisis, that we were losing doctors in various parts of the state. People actually were leaving because they couldn't get insurance, they couldn't pay for the insurance, the climate was so bad, they weren't able to stay in practice. And since that time, we got the Constitutional Amendment. This slide shows the increase in areas of the state in terms of availability of physicians, more physicians coming into the community. And then here's another state that shows gains in ER physicians by county, where counties were able to increase the numbers of doctors in the emergency room as a result of the tort reform efforts. Another slide that we have shows the increase in specialists in rural areas. So we've got emergency medicine, which is the purple color, obstetricians is blue, orthopedic surgeons green, cardiologists red, other specialties is the dark blue, shows how they have increased as a result. Texas is somewhere around, I can't remember exactly, 40th, 39th in ratio of physicians to population, because the Texas population has been growing tremendously as well during this time. But we were able to increase that ratio and increase our numbers and do better in that area in spite of the population increase. We were able to keep up with physicians and actually lower that number down so that we have a better ratio than we used to have in spite of the great increase in the population that's happened in Texas. Here are the rural areas where we were able to add obstetricians since the last time, since 2003.